Hello, welcome to today's interview. My name is Lucy James. I'm Operations Director with Insight IP Limited. Insight IP provide services to legal professionals, and today I'm going to be speaking with Mr. Keisaku Ishihara, Managing Partner with Nagoya International. Nagoya are one of the top firms in Japan, representing both national and international clients in the field of IP. I've previously worked with Mr. Ishihara, hosting boardrooms as part of the Insight IP virtual boardroom series on acquiring IP rights in Japan and enforcing IP rights in Japan. And forthcoming, we'll be looking at exercising your IP rights against infringing goods in Japan. So I'll be speaking to Mr. Ishihara just now to get a bit of a flavour, an idea of what we're going to cover in that boardroom. Let's see what he's got to say. Mr. Ishihara, hello, how are you today? Hello, Mr. Ishihara, how are you today?
Great. How about you, Lucy-san?
Thank you very much. I'm doing really well, thank you. Thank you so much for being able to join me. I'm really glad we've got this opportunity for you and I to chat ahead of our boardroom in a couple of weeks.
Well, yeah, both my pleasure. Thank you very much for having me with such a very important event that your company is having.
Thank you. Mr. Ishihara, I'm going to get straight into it, but you know that when we've done our boardrooms before, we do like to start with a bit of context. And given that this one is looking at the landscape for trademarks in Japan, I was wondering if you could provide us with a bit of context to start with, please. Perhaps some numbers and some context about how that is changing in Japan at the moment and how it's changed recently.
Okay. Before starting, well, you mentioned the trademark, but we are going to cover actually lots of areas, not only with regard to trademark, but also even the patent. So in other words, current situation in Japan concerning entire IP, something like that. But anyway, to answer to your question, the number of trademark, well, your question is particularly related to the international companies' activities in Japanese market in terms of trademark. And the number of trademark cases filed in Japan by international companies, for instance, looking at around 10 years ago, in year of 2011, the total number of which is about 23,000. And now, well, the latest figure I have at my hand is with regard to the figure in 2020, which is more than close to double, about 46,000, concerning their total number of filings made by the international companies. And major countries of origin of these international companies are from European countries, the US, and China and Korea. And well, for your reference, the number of trademark cases filed in Japan by domestic companies are 95,000 around in the year of 2011. And that was corresponding 163,000 in 2020. That's my answer.
Wow, that's some pretty good numbers, isn't it? That's honestly, all of those are higher than I was expecting.
Yeah, and therefore the Japanese examiners are having very busy days now,
Yeah.
and I have to be very time efficient when discussing each one of the cases with the Japanese examiners in trademark department.
And if I understand correctly, the guidelines for trademarks by the Japan Patent Office are currently under review. And I was just wondering if you could give us some of your thoughts on what we can expect from that review, from those changes, please.
Well, the things currently under its review is related to their handling of their counterfeit goods imported illegally from outside Japan. And then that's actually not for the prosecution side, but rather concerning how to stop their counterfeit goods crossing the border. And then, and on the other hand, to answer to your question directly related to the review of the examination guideline, the most recent revision occurred in examination guidelines for trademarks was made in March of 2020. And that revision was related to the three-dimensional trademarks. Specifically, that's related to the shapes and figures of exterior and interior of a store that can be registered as a three-dimensional trademarks. So the thing made as a review in the examination guideline was to add the specific to add the clarification on how to approach to the determination of the distinctiveness of such a three-dimensional trademarks in the examination. And actually, meanwhile, your question is only related to the trademarks, but the related big change has occurred in the Design Act in our IP law, and then that's related to the new additions of the subject matter to be protected. And that is actually covering corresponding to the three-dimensional trademarks I mentioned, architectural structures, both exterior and the interiors as a design subject matter. And additionally to that, mere images themselves are now, the parts of the design registration in our jurisdiction. And a unique one, which could have broadened a lot of space for the design owner for international company, is the expansion of their what we call the related design system, which can cover the similar design to the parent design, which was registered as the original design, which could cover up to 10 years since the publication of the design gazettes of the parent design, which needs a big advantage for the owner of the lots of appealing designs to the customers of those international companies.
So this is one of the things that I think is so valuable in our conversations, but at the boardrooms that we do, is the amount of technical information and updates, that you're able to provide, it happens every time, doesn't it, that our attendees benefit from, this very technical, important sort of specifications almost, well, it is, which it's always brilliant to hear about those sort of updates that everyone needs to be able to do, the correct, precise work. But I do want to ask you a follow-up question, which moves into more of the soft field, which is
that's completely fine. Yeah, and more practical.
Well, when we talked about enforcing IP rights in Japan, you had so much to say about how Japanese culture influences that process. And I know we're covering more than trademarks at our boardroom on March 11th, but I really want to know from you, how much does Japanese culture influence the negotiation of trademarks or at all? I'm curious to know.
Well, that's 100% similarly applicable even to the negotiations in trademark fields. And, actually, as you can possibly imagine kind of easily, the brand owners, the trademark owners in Japanese markets are very, very widespread, from the big companies to startups or even to the individuals. So that's that fact itself is indicating that there is a big importance of understanding the Japanese culture in business-wise to discuss the case with the counterpart to achieve the realistic goal in a time-efficient manner for international companies.
Excellent. Okay. Good. Again, I ask you a nice soft question. It's back to those technical details.
Whichever is fine.
They are. It's all linked together. But again, you've mentioned just then international companies, and I'm glad because that's something I wanted to move on to asking you. Another thing I recall you mentioning is that the Japanese courts were seeking to be more internationally competitive. And I wanted to ask if you have seen or are expecting any specific updates or changes, but specifically around software patents.
Oh, okay. Now
Yeah.
you're talking about the patent side,
Now I've
particularly.
moved to patents. Yeah.
Okay, okay. um, in well, to answer to your question, okay, that needs to mention step by step. As I mentioned in our boardroom last year,
Yeah.
I feel that Japanese courts have shifted their system to be more rewarding for patent owners. The Revised Patent Act in force in, if I remember correctly, in April 2020 includes a revision of the calculation method to determine damages patent infringers should incur in a manner favorable for patent owners. And this revision is also entirely applicable to software-related patents. And in addition, the inspection system introduced in October 2020, same year, have made it easier to shed light on evidence of infringement that is only possessed by an alleged infringer side through judicial proceedings. And I believe this inspection system have made it easier for patent owners to prove infringement by themselves compared to before. For example, in an infringement lawsuit involving a software-related patent, an inspector in this newly started system, inspector will visit the facilities of the alleged infringer and actually see the operation of the software and of the alleged infringer to collect useful evidential materials in determining the act of infringement. And moreover, recently, patent invalidation is less likely to happen in Japan.
Yeah.
According to statistics, well, can I move on? Statistics says that the percentage of patents that received invalidation decision out of patents subjected to invalidation trial was over 40%, 40% in the year of 2009, but was decreased to less than half, about 17%, 17% in 2019, and which remains also today similar situation. So
Excellent.
that's
Well,
the answer.
brilliant. Thank you. Again, a fantastic amount of detail. I'm going to follow up immediately and say, have you got maybe a similar sort of update or any update you can give me with regards to standards essential patents in Japan and anything that's changed in that part of the market at all?
Okay. With regard to that aspect, I should mention from the wider perspective. I mean, from the macro perspective. In other words, I think Japanese companies and are actually now individually struggling to find out how they should approach the current situation. Where SEPs are involved. And meanwhile, our Japanese government, to be exact, Ministry of Economy, Trade and Industry, started to draft a rule of good faith negotiation, what they call a good faith negotiation guideline involving SEP in December 2021, quite recently. And it is reported that this rule is expected to be used once completed by many different concerning parties in Japan, such as those in Japanese industries, those who attend the negotiations involving SEP, and even the Japanese judiciary.
Okay, So there's a few changes there, but they're changes with big impact, important changes. And I think actually you've anticipated my next question, which I was going to ask again, whether these were changes that would make Japan more competitive in the international landscape. And I think really you've answered that question, which is yes, they are steps towards being more competitive in that space, aren't they? So, Mr. Ishihara, I'm going to move us forwards in time. When we come to our boardroom on March the 11th, and you are right, we will be talking about more than just trademarks and the trademark landscape in Japan. But tell me from your point of view, what else is going to be covered? What else can we look forward to at that meeting, please?
Okay. Let me put kind of in an indirect way to answer to your questions. Actually, topics introduced in the flyer very wide, but our field of expertise with abundant experience. Well, if I mentioned in a straightforward way, and I'm therefore very comfortable and ready to answer participants' random questions in these topics. And so please, my comment to the potential participants is that please participate in our boardroom and throw your questions at me to get a specific idea of how your company should build IP strategies to compete in the Japanese market.
Perfect. Perfect. What a brilliant way to set up that meeting. I mean, as you and I know, these boardrooms, they last about 90 minutes, 2 hours, don't they? And you're exactly right. That's what a participant can get from that opportunity. They come, it's a virtual boardroom, so they're wherever they are, but they participate. And that's exactly what they can take away from it. They can get all of the input from you on how to be more competitive, aggressively competitive in the Japanese market.
Very active conversation, dialogue. Yeah, lots of questions moving, going forward. Yes.
Brilliant. Well, look, Mr. Ishihara, I will very much look forward to seeing you on the 11th of March. It's always a pleasure to work with you. It will be a pleasure to speak with you then, and we're looking forward to another excellent boardroom. I know it.
Yeah, thank you very much. I'm very looking forward to it too.
Thank you. See you then. Thank you, Mr. Ishihara. So it's always really advantageous to be able to get a conversation like that, some insights, a bit of flavour about what we'll be covering ahead of one of our boardroom discussions. Our discussion on the 11th of March will be looking at the legal options available to exercise your IP rights against infringing goods in Japan. Of course, we'll be covering trademark and much more, as Mr. Ishihara just said. If you'd like more information about Insight IP or to register to join us for that boardroom discussion, you can go to the website or you can send us an email. The details are on your screen just now.